The following is a production of Cary TV, the Town of Cary's government access channel.
Call to order the July 7th Quasi-Judicial meeting of the Cary Town Council. Ms. Robinson will not be with us this evening. She recently lost a loved one, and I would ask that you keep her and her family in your prayers. Okay, we want to start this meeting with the Pledge of Allegiance, and I would ask that you stand and join me. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We're at agenda item 1.2, which is the adoption of our agenda. I would entertain a motion to do so.
So moved.
Second.
There's a motion and a second. Discussion. All in favor, please say aye.
Aye. Aye.
Any opposed? Motion carries unanimously. Our only items of business tonight are the Triangle Limited Annexation Request and Be Safe Self-Storage Quasi-Judicial case, which are related. However, it is my understanding that a motion has been made for the continuance of these cases. Would the person presenting this motion please come forward?
Hello. My name is Tiffany Taylor. I live at 108 High Pine Court, which is the property just beyond where the development is being proposed. On behalf of Northwoods community and neighbors who reside off of Chapel Hill Road, we would like to request a continuance of the hearing for the application for the special use permit. We appreciate the opportunity to participate in the local government process and would appreciate the opportunity to properly prepare for this opposition. We were notified of a July 7th hearing from a letter dated June 16th, and we do not believe this is a reasonable amount of time to build an opposition for this development. So we would like to request a continuance until August 4th or ideally August 25th. Due to the 4th of July holiday, many people who want to participate have been unavailable, and this would allow us enough time to coordinate. We would like to have an attorney represent us and also provide expert witnesses, such as a city planner, who can contest to the incompatibility this development would be for our community, and a real estate broker or appraisal who can show the impact this will have on our property values. Thank you.
Thank you. This time, I would invite the applicant to come forward and address this motion.
Thank you, Mr. Mayor. My name is Tom Worth, Jr. I'm the attorney for CIP.
construction company, the applicant in this matter. First, I want to interpose an objection to the standing of the neighbors to express their opposition tonight and prospectively in this matter. We will challenge that, and I want to make that extremely clear to the neighbors. On the matter of the continuance, reaching back to June, we were poised to be on your June quasi-judicial agenda. We were informed that you had an overloaded agenda, and we would have been one of 4 cases, I believe. Under the circumstances, we felt it not appropriate to impose upon you or the staff to be heard in June. Therefore, we opted for July. We became aware of the opposition of the neighbors. At the suggestion of staff, we reached out in an effort, a failed effort, to have dialogue with the neighbors. The matter of the continuance we knew was out there, but we were not going to agree to the continuance until the sad events of the 28th that has resulted in one of your members not being here, with a visitation that begins in 25 minutes. Under those circumstances, when I found out about this at 1:54 yesterday, I immediately called my client and said, the right thing to do is to not proceed tomorrow night, i.e. tonight. And it was the right thing to do. It is the right thing to do. And Mr. Roy Carroll, the head of these companies, concurred immediately. The question is when. Our witnesses were all poised to be here tonight. We undid that, 3 in Wake County and 3 in the West. We have undone all of that. But what we would request, rather than the 4th of August, is consideration for this hearing sometime before then. I understand that you have a work session on the 20th. Apparently you've got other items on that agenda, but we would very much appreciate consideration of July 20. I have polled my witnesses, and although we lose one, unavoidably, I do have a colleague of his who will stand in for him. So I hope that you will consider this request respectfully made. And again, I regret the circumstances for this continuance, but again, it's the right thing. I'll be glad to answer any questions that anyone may have. My address for the record is P.O. Box 1799, Raleigh 27602. And I thank you for your consideration.
Thank you. So I would ask that staff come forward if they have anything to add.
Staff doesn't take a position on the continuance, but we'd be happy to help you in a discussion of dates if you're so inclined to grant the motion.
Okay. And if council is inclined to grant the motion, I would ask that you give us a date and a time in your motion. So I'll open it up to council members for comments. Motion.
Question.
Questions.
July 20th work session. What is on the agenda for that work session?
It's busy, to say the least. We have 3 items on the agenda, and they're lengthy. If you want to know the 3, they are Imagine Cary, I believe a council-initiated item, or...
It's the calendars.
Okay, a calendaring issue. And the 3rd one we talked about today.
We did talk about it today.
Rick Perry must be a friend of yours.
The library?
The library.
Thank you, Mayor.
Thank you.
I knew that was coming back.
Yes.
Okay, yeah, that's going to be...
But lengthy topics.
They're going to all be discussion items, yes.
Okay. And do we have any idea of how many items we will have at the August 4th quasi-judicial meeting?
I think as of right now, we have nothing pending for August 4th. September may be busy, but August is looking empty.
So we have a 20th requested by the applicant, 20th of July, and we have the end of August requested by the person making the motion. So, I mean, August 4th seems like
Fair compromise.
Yeah. And it's the scheduled quasi-judicial night.
Yes.
They,
Go ahead.
well, they requested the 20th, so I wondered if, and you polled your witnesses, I'm just wondering if there was, if he had problems on the 4th with conflicts with getting his witnesses here. Because he could have had them all here tonight, but he deferred. Yes.
Thank you very much. I lose a critical witness to a hearing in Montana. So August 4 is not available for a critical witness. All witnesses are critical, ladies and gentlemen, but there are some who are more critical than others.
Would you have that witness available at the end of August?
I can't answer that. I know that he goes from his hearing situation on to vacation, which I can understand. So I do not know the answer to that question. But the additional time on a matter that my client started in January of 2015 to staff on April of 2015 is becoming a real concern. And so, again, we don't want to burden you, but your consideration of our dilemma would be much appreciated.
Let me ask you, do we have an option of maybe, if we got such a full work session on the 20th, I know Imagine Cary wouldn't be good to move back. I know the calendaring wouldn't be moved back. If the library can't be moved back, then we don't really have a choice of clearing.
Yeah, they're all time critical.
They're time critical. We can't really move any of those back that I understand.
Right.
Okay.
That's correct.
Okay.
And we usually don't ask witnesses to come back unless we have a question. So if a council member has a question, we can call you back. Other comments?
Well, I think I want some clarification here.
Okay.
For a quasi-judicial, are we allowed to, or have we ever entertained where, when it has already been extended? I mean, this all started back in June, and then, you know, with their compassion, they moved it on the 28th. So I feel this dilemma between a item that's been in the works for a long time, and I may be misreading it, but I don't get a sense of discussion going on, like with our other cases where we encourage the applicant and the adjoining neighbors to meet. I guess the question I'm asking, is it really reasonable and fair out of the blue to get a request for a continuance when the applicant has already made special accommodations to help us? I mean, that's what I'm struggling with. Now, the 20th was a hardship for me anyhow, and we have for the day. I mean, should we allow this to go to the 4th? That's the question.
I guess I'm confused about the schedule of events. Was it ever booked for June? For instance, when did the citizens get their notification?
Yes.
Asking staff?
No, the citizens' notification was based on tonight's hearing date.
Okay, but they did not get notification for the previous.
No, Mr. Hales can speak more to the staff process. I think his interpretation may differ a little bit with Mr. Worth's about the timing.
It was penciled in June. There were 4 items at that time, and my understanding, and Tom can correct me, Mr. Worth, they were trying to line up their witnesses, and it worked better for them to delay it, and it worked well for us to delay it. But it was never actually formally scheduled for the June meeting. It was always we pencil everything in months in advance, and then as things firm up, we notify once we're sure something's going to a particular meeting.
So it was never essentially scheduled for June. It was essentially it was scheduled for tonight.
It was in a basket of 4 cases that were potentially going in June, but it was never formally, we advertised, notified neighbors, and everything else.
Okay.
Right, so the notification to the neighbors was based on tonight's hearing date and was made in accordance with requirements for notification ahead of time.
And they were notified on what date?
She indicated June 16th, and that's probably sounds about right.
Other comments, questions? Anybody want to make a motion? Or we can continue with the hearing.
We won't have his witnesses.
He won't have his witness.
He-
That's
he's
right,
already
but we don't have to
accommodated.
continue.
He's
it.
already,
Am I correct, Mr. Gay?
Well, if the parties have consented to a continuance and his witnesses, he's told his witnesses aren't here for that reason, I would think the board would want to continue. But
And
don't
I
think
agree with
legally
you.
You are required.
But I'm not
It's just
hearing a
when.
motion.
Okay, so I guess I'll see how, put a straw man out there.
All right.
I certainly understand the request, and I appreciate the acceptability that, and your flexibility to allow us to go and be there for support of our council members. So thank you very much for that. I'd like to make a motion that we push this off to the date, the next quasi-date, which is
August 4th at
At what
6:30
time?
PM.
You have
It's
to
at
say
6, sorry, I think it's at 6:30 on August 4th.
It is in the council chambers.
In
Thank
the
you.
council.
The full motion.
So
Full motion.
there's a motion, a second. I'll repeat the motion. Continue this hearing to August 4th at 6:30 in the council chambers. Discussion.
Yeah, so I feel, if a critical witness won't be here for that, and he's deferred to us, I'm here to be inconvenienced. I don't have a problem with starting early on another night, so I don't feel like we ought to, I feel like he's, avoided the holiday when people couldn't be here, which is questionable whether we should even have something scheduled the week of the 4th anyway. And then if he can't have his witness here, a critical witness here, I wouldn't want to proceed far without a critical witness if I were presenting. And I'm willing to be inconvenienced, so I'm not in support of the motion for the 4th, because I'd be more in favor of doing it the 20th and being inconvenienced myself for staying late or whatever. That would be my position.
In my opinion, it's more than being inconvenience. You add a 10-hour workday to 3 hours of work session, and now I've got to do something well, they're all important, but this would be extremely important. That's just a lot to ask of an individual. I don't know about the rest of the people's daily schedules, but that's really taxing on me to focus for basically 12 hours nonstop, so
Yeah,
whatever it would
and
be.
I'll just, since I made the motion, just to comment on the motion, that is exactly what I was thinking is the question that we've always had when we back up a work session with some sort of town council meeting, which we've done before, is if we make the quasi-judicial meeting after the work session, then that puts an absolute deadline on our work sessions. And I've always noticed that when that deadline is in place, our
rush the
discussion,
judge.
it rushes our discussion. We don't do the best due diligence in the meeting. I've seen it before. And then if you could put the quasi-judicial first, and then, we have the same thing going on. So we already have a quasi-judicial schedule in place. If that doesn't work for the applicant, I would hope that staff would say, okay, well, if August 4th doesn't work, I would be amenable to another date after that. But I don't think we do our best work as a council, and I'll just only speak for myself, when we try to slam too much into one day.
Well, that's what I'm sitting here wondering, and I also echo the concerns or the sentiments of Ms. Bush regarding the applicant's willingness to accommodate the council. Would the applicant prefer August 4th or the later date in August?
Yeah, thank you for saying that. That's a great idea.
What is the later date in August?
It is.
25th, did you say, or 24th?
There's a regular council meeting on the 25th, and then the next quasi is September the 1st.
the July 25th is a real full council meeting.
Yes.
That's what
Yeah.
I looked
But this is August the 25th.
August.
Okay.
And I'm unaware of,
Well, I thought you said July, and I wanted to make sure that,
We could have a quasi-judicial
During
a regular council meeting,
if council wishes to, yes.
okay? Because that date, to me, seems to work very well for the people requesting continuance. What would the applicant prefer?
Well, I'll probably face a divorce because my long-suffering wife and I are supposed to be in Bermuda there, no matter what August.
Don't do that.
And,
well, this is getting fun, isn't it?
well, I'm not going to tell her about that question. But,
No,
So September 1st, you would still be in Bermuda?
no, I think I'll have her back by September 1. I'll probably have The client will probably have a new lawyer, though, because
Well, we
There
were,
are other dates. I'm
we
sorry.
were emailed options today, and I don't have my calendar here, but I remember one of them was July 27th.
I left it in there. I had the options.
She just said,
Here it comes.
okay.
I can pass that out.
And, I mean, that's a conflict for me, but I have time to change it, type of thing. The question is, as a council, do we want to set up a special meeting for the 27th, or even on the 28th with Imagine Cary?
So there was nothing after August 4th.
No, there's nothing on there after. I'm trying to move it up where we respect the delays that the applicant accommodated, and at the same time try to deal with a last-minute request from the citizens. We're just trying to balance them all out. I mean, I could personally make the 28th. I think the 28th. It's an option for us to be at the Imagine Cary, and I would be, since we're used to Thursdays, and we have an opportunity, I think, to attend some of Imagine Cary next door. I would be open to the 28th. And I'm just saying I'll be open to it, but
So it seems,
I don't want to get into calendar management here. and that's what we're into.
it seems like this hinges a lot on an expert witness. Can an expert witness provide testimony via a statement?
You really
You
need,
can't be cross-examined.
them present so
Okay.
the other party can cross-examine.
Just checking.
My only concern with having all this discussion of dates is we do have a vital member that's not at the table too. So just considering that if we come up with the 27th or whatever date it is, Jennifer's not here to.
There's not going to be a perfect date, one way or the other, no matter what we sit here and agonize over.
Except for the dates that are already
Don't know
reserved.
about precedent. I mean, we table and continue things, not necessarily quasis, but other items all the time, and we always do it to the next scheduled or to a regularly scheduled meeting. I don't recall a precedent of picking a date in between meetings to do these things, which is why I seconded the motion for the 4th.
So we ready to try out the 4th and see if that flies? There are 6 of us, so there'd have to be 4 to approve. So the motion again is to have the hearing continued to August the 4th at 6:30 in these council chambers. All in favor of the motion, please say aye. Aye. Those opposed?
No.
No.
Did you?
Yeah, it was aye.
Motion carries 4-2. So the hearing is continued.
Mr. Mayor, may
Yes.
I interject briefly?
Yes.
Mr. Worth mentioned that he would object to a potential standing issue as to whether or not the neighbors have standing to bring this challenge. To expedite things, my suggestion would be to have the parties, in particular if the neighbors are going to retain an attorney, to brief the standing issue and present something to the town maybe 4 or 5 days in advance of the hearing. That's a jurisdictional issue that comes before getting into all the substantive matters related to the challenge. And if a brief was done and submitted to the town, it may expedite the hearing and also give either myself or Mr. Silverstein an opportunity to be prepared for those issues that may arise.
So let me understand that the brief cannot be presented to us as a group, have to be presented to us individually because we're not allowed to discuss.
Well, they could, the brief would be submitted to the town staff, and then the staff would forward that to us, to myself or Mr. Silverstein. And that way we can be prepared for that issue should it arise. He's indicated that he will make that motion. And since it's a jurisdictional issue, it really comes before getting into all the evidence that you would hear as a board. You would still have to hear the standing issue. But if you determine that the neighbors do not have standing, for example, you wouldn't go any farther than that. So it would be an opportunity for the groundwork to be laid and potentially save some time instead of starting from scratch on that night. And it's purely a legal issue.
So help me with the action that you're requesting or suggesting.
Absolutely. So it would be my suggestion that you require of the parties to submit a brief addressing the issues of standing 4 or 5 days prior to the hearing date, and that brief would be submitted to the town staff.
I would suggest that it be submitted by Thursday, July 28th.
Okay. So we need that in form of a motion.
Well, I'm sure some are shy and they don't want to bring it up, but, for some that may not quite understand all of this, just go through the point of standing. Is it that you're challenging that they even have the right
So
step forward?
The courts in North Carolina have stated that in order for an aggrieved party to even challenge a special use permit or other types of approvals that local governments do, they have to meet certain burdens. They can't just say, well, we don't like this.
Yeah, they can't just say, oh, I want a continuance because I want to do, yeah.
Right, and if so in order to have standing, you have to meet certain criteria to even get you there.
Okay.
So if Mr. Worth is going to challenge whether they have standing or not, it would potentially save the board a great deal of time to have all those issues in writing prior to the hearing, and we can get right into it instead of starting from scratch.
How would that actually impact our meeting and our discussion in the hearing itself? I mean, if he's challenging the group's ability to even protest continuing, which we've just continued.
Right. For one, we don't know.
We're going to spend the whole night talking about should we have continued or not, or are we going to spend the evening actually listening and talking about the facts of the case?
Right. We won't get back to the reasons for the continuance, but what it will do is the neighbors will say what the issues are.
Right.
So the board will then know whether or not, in advance, know whether or not they have standing under the law, and the lawyer can give you guidance on that.
And Mr. Gadd, if I can interrupt for a second, my understanding of what sort of the practical implications of all this would mean for you, even if they don't have standing, for instance, at the end of the day to appeal a decision that you all make, the decision you make on the special use permit and the site plan, they may still be able to have witnesses, the neighbors, to have witnesses testify. So I think we may still end up hearing testimony. You still have to decide whether that testimony is relevant, whether it's competent, meaning they have experts and that sort of thing. So I think Mr. Worth feels he needs to make a motion to object to their standing. But I think for practical purposes of how your hearing would run, your hearing's probably going to run about the same either way once you deal with the standing issue. And we, all the lawyers involved will, I think, end up talking about this. If the neighbors are able to retain an attorney, as soon as we know who that is, we would all like to speak with that person so that we can discuss some of these procedural issues ahead of time and try to work as much out before it comes back to you so that the meeting is more efficient when you see it again.
Just one quick question, because I'm confused. We have rules and guidelines in which we're not allowed to speak about this prior to the actual quasi-judicial. So, but you're also talking about us seeing some document about standing. You said the board would be able to see it before.
I'm sorry. I meant the lawyers.
The lawyers is what you meant, not us.
I'm sorry.
Okay.
And then staff would be prepared, but we're not really getting in the weeds on that.
And the citizens know not to send anything to us
before. Don't send anything to us.
Don't send anything to us.
Yes, I think they've been communicating through Mr. Hales, and they can continue to do that at this point.
But, I'm sorry I've got to get this clear, but, we've had, like, cell tower cases, and then we get here, and we have groups show up, and none of their witnesses are eligible. Expert witnesses are eligible. So I just feel like, I don't want to set any crazy expectations.
We can rule if they're non-expert witnesses that testimony is invalid and ask them to stop, but usually we don't do that.
No, we don't, but the attorneys for the applicant usually
Can cross-examine and basically say, this is not an expert witness, this testimony is not valid. Am I correct?
Okay, well, I don't want to talk about the case, but, the person came up and mentioned some things that just really troubled me because I don't want to say anything. Never mind.
In summary, quasi-judicial hearings are very complex, even to those who do them all the time. Do we want to do a motion as
For-
suggested by Mr. Gadd, and the date was suggested?
To require
28th.
briefs on standing by July 28th to be submitted directly to Mr. Gadd.
That'd be fine.
So moved.
There's a motion. Is there a second? I'll second it. Discussion. I looked at perplexed faces.
I guess I don't see the reason for it except to maybe allow both groups the opportunity to get their thoughts and opinions down on in a very organized fashion. And if that's the case, if that's the goal of this, then I guess that's worthwhile. But we've never had this. Well,
we've never had a last
I've
minute
never had this
continuance.
before.
The key phrase, I think, was expedite the process.
Yeah, this is a unique situation for you all, but if we were in a courtroom, it would be very typical for parties to submit briefs on their motion before the judge would hear it. So that's essentially what we're kind of asking them to do in this case.
And then who would pass, I made the motion, but who would then pass judgment, or an opinion would come forward that night from Mr. Gadd and Mr. Silverstein about the validity of an explanation would happen? Okay.
And it will ultimately be the council and the mayor who decide the issue.
Okay. We have a motion and a second. Any further discussion? All in favor, please say aye.
Aye.
Those opposed? Motion carries unanimous. Mr. Gadd, is there any other business? Okay. I would entertain a motion to adjourn.
So moved.
There's a motion. Is there a second? And a second. Discussion. All in favor, please say aye.
Aye.
Any opposed? Motion is approved, and we are adjourned. Thank you.
This has been a production of Cary TV. Visit the Town of Cary's website at townofcary.org.